Hello and welcome to today's webinar, in which we aim to make an overwhelming case for robust action by the International Criminal Court, the ICC, to address atrocity crimes committed since last year's coup in Myanmar and come up with a list of specific actions to make that happen. I'm Chris Gunnis, Director of the Myanmar Accountability Project, MAP. Today, to mark a year since Myanmar's Democratic National Unity Government made a public declaration to accept the jurisdiction of the ICC, we're publishing a substantial legal opinion which provides an exhaustive legal analysis of why the ICC has the power and the responsibility to accept the NUG's declaration. A link to the opinion and to an op-ed in The Diplomat based on it is in the chat. We have with us the author of that opinion, Dr. Ralph Wild of the Faculty of Laws, University College London. We're also joined by a distinguished panel of experts to talk us through what we can all do as activists, scholars, civil society groups, journalists, business people, diplomats, and politicians to make the ICC address atrocity crimes in Myanmar. And by the way, we'll be coming to a question and answer session after the panel, so please leave questions in the chat box saying who you are and who your question is for. Now, to provide us the context of all of this, I'm delighted to welcome the NUG's Minister of Human Rights, Aung Min. Minister, welcome to our event. Thank you so much for sparing us your time. Can I ask you for an overview of your main areas of concern and a real sense of the emerging trends, the types of human rights violations we're seeing in Myanmar today? Minister, please.
Thank you, Chris. Thank you for inviting me, giving a chance to talk about the human rights situation in the country. Tragically, the violations are well known to everyone. The situation has been the most terrible situation in the history of Myanmar. All the human rights violations and crimes has been comprehensively documented by the UN High Commissioners for Human Rights and the Special Rapporteur of Myanmar, and then also including were documented at the Independent Investigative Mechanism for Myanmar. Myself, as the Minister of Human Rights, we have been receiving thousands of cases of murder, torture, arson attack, arbitrary detention, and the weaponization of aid. There's many cases of airstrike against the civilians and villages, the forced displacements of over 1 million civilians, widespread and systematic war crimes and crime against humanity are being taken place every day, I would say, and almost everywhere in the country right now. At the June session of the Human Rights Council, Mr. Don Andrew, the Special Rapporteur of Human Rights Situation in Myanmar, described atrocity against children. That includes a hostage-taking, stabbing and burning, sexual violence, mock execution, deprivation of food and waters, and denial of medical care, especially in the areas where intensive fighting are taking place, especially in the ethnic areas. About 30,000 villages were burned down, and 30,000 houses were burned down, particularly in Sakai Division and as well as Chin and Karenni states. About 15,000 activists are arrested. What they did is a political activism and fighting against the military. But what they received is torture, mistreatment, and ill treatment against them during the interrogation, detention, and also even in the prisons. There's 68 men and 9 women being charged with the death penalty and subject to the execution at any time. They did not have any legal rights while they are arrested, detained, and charged. They are arbitrarily arrested, charged without any legal rights by the military tribunals. So the overriding trend is continuing escalation of gender atrocities. At the same time, each effort by the international community is met by haunted rejection or reprisal. There's so many examples, but I want to pick up a couple of examples. On the same day of the UN Special Envoy of Myanmar announced that she would visit Myanmar, the military junta added 6 years to the political imprisonments of Aung San Suu Kyi, who continue to be held in solidarity confinement despite repeated condemnation by the UN Security Council and General Assembly. And then the terrorist junta execution of 4 prominent democracy activists right before the ASEAN Foreign Ministry meeting on 3rd August 2022. And despite the ASEAN chair's public plea not to commit that kind of execution. This is clear, deliberately policy. UN appeals, ASEAN appeals, yet new frontier of gender terrorism. On Wednesday, we saw the UN Special Envoy Noeleen instrumentalize the gender propaganda, photograph shaking hand with the war crime. So this is the current situation. You can name it. We have so many human rights violations taking place right now. It's
Minister, thank you.
Thank you.
Thank you, Minister. So I'd like to move to the ICC, which is the subject of this webinar. As I said in my introduction, the NUG made a declaration a year ago that it accepts the jurisdiction of the court. What response did you receive from the ICC?
Well, you know, the NUG make a declaration that accept the jurisdiction of the ICC and requested the ICC to identify, examine, investigate, prosecute, and jurisdicate all crimes in the territories of Myanmar since July 1st, 2002. I would say it again, all crimes in the territories of Myanmar since July 1st, 2002. We received the acknowledged letter of our declaration. NUG has opened up a productive dialogue with the ICC and welcome that exchange. For now, we continue to wait for the formal response to our declaration. We are still waiting to have a more productive, engagement and formal response.
So just to clarify, Minister, you're saying you've not received a formal response from the ICC to your declaration?
Yeah, this is true.
So what do you understand as the main blockages to the ICC accepting the declaration, or at least responding formally to it? Have they made that clear to you?
Chris, this is the question best put directly to the ICC. In the absence of the formal response to our declaration, we don't want to make an assumption about the ICC thinking. Sorry about it.
No,
there's two processes. Yeah, but there are two processes that likely continue to have an influence on the ICC. One is the active case. Sorry.
No, continue. One is the active cases.
Yeah, the first one is the active case before the International Court of Justice under the Genocide Convention, known as, the case of Gambia versus Myanmar. As soon as the ICJ displaces the military hunters from the case and accept the NUG agent, then ICC will be much more inclined to accept our declaration. And so, second one, please. General Assembly recognition is important too.
Yes, now MAP is going to be working on the question of the General Assembly, the Credentials Committee, and all of those questions of recognition at a later stage. And I hope we'll indeed have another MAP webinar. We may have another MAP webinar about that. But if I can ask you, Minister, staying with the ICC, what do you want to see next? You've described the situation, but in your best case scenario, what would you like to see happen?
NUG is committed to continue to look for the justice and accountability by all means possible, because this is very important to bring justice. So we want the ICC to take actions and then bring the cases of Myanmar to the ICC court. So there's an option before the ICC. These are what we like to see. But there's the option before the ICC Two active ones are the number one, accepting the NUG's declaration and immediately opening a countrywide investigation, or number two, expanding the current investigation focused on Rakhine State, activated under Bangladesh ICC membership. So these are the, the process we really want to see the ICC action on the case of Myanmar.
Can I ask you a question, though, which we discussed a little bit before, and it's quite a delicate issue. Why didn't the NUG seek to become a party of the Rome Statute and then just refer the situation in Myanmar to the ICC itself, which would have been another route?
We have reviewed all possibilities how to engage with the ICC and take the cases of Myanmar to ICC. There's several cases, several procedures, but we learned that the submission of the declaration using Article 12.3 would be the most easiest as most less complicated legal way to get the action as soon as possible. That's why we choose that, declaration. But, we make a public announcement that, NUG is willing and very committed to ratify the ICC when their time is ready.
Another potential route would be for a state party at the ICC to refer Myanmar. Have you considered that? Have you indeed been in touch with any of the state parties about such a referral?
Since we are calling and we are committed for the justice, we always raise using international accountability mechanisms at any meeting with any international organizations or any individual or regional the government. So ICC, one of the options, we believe that we could bring the justice back to the people and also make accountable for the perpetrators who enjoy the culture of impunity in the country for generations. So whenever we have a meeting, we raise the issue of support for our ratification of the ICC, and also not only the ICC, asking them to support any kinds of accountable mechanisms that would make the justice available and reliable for everyone. We regularly raise ICC issues. Out of discretion, I will not identify specific states, but we have strong relationship with many of the 123 state parties to the Rome Statute.
It's very reassuring to hear that, Minister. Thank you for that. So I want to end this little section with you by asking about that to-do list, which I said we want to draw up, a list of practical recommendations. You've already outlined quite a few, but are there any for the various stakeholders in the ICC that you would prioritize, actions which you can say you want taken in the immediate future, perhaps later in the long term?
Well, I'd really like to support the MAP, organizing this kind of thing. So everyone is aware of what is the stage of the NUG engaging with the ICC. And also, we also look for the other alternative way, because it would take time. So we calling, we can think about the beyond the ICC, that is like, how would I say, we also need to look beyond the ICC. The one step is the creation of the ad hoc tribunal on Myanmar. In this new report, the IWM say that it has nearly 3 million information items, including interviews, statements, and many evidences. Now it needs a ready jurisdiction. The General Assembly should explore the creation of tribunal on Myanmar, like the previous countries. So it is important to find any other alternative way while we are still, engaging for the ICC. Secondly, it has been actively supported by MAP. We need countries to exercise their universal jurisdiction and pursue persecution in their own national court. The WINWM says that it has prepared over 67 packages with supporting information and analysis to be shared with the relevant authorities. So the materials are there. So while we are engaging for the ICC, we also look for the other alternative way of accountability mechanism. We need support for civil societies to lobby with the government, and we need support for the state to support our call for ratification and declaration to the ICC.
Minister, that's a great start to our to-do list: ad hoc tribunal, universal jurisdiction, civil society, lobbying member states. We already have in the chat box, Minister, some questions to you and some very sweet messages of support. And we'll come back to you later, if I may, in the Q&A, but please do keep those questions coming in for Minister Myo. I'd like to bring in Dr. Ralph Wild, who, as I said in my introduction, has written a substantial 20,000 word, I should say, legal opinion, which we are publishing today after sending it to the NUG, to the states parties to the Rome Statute. MAP's administrator, Emmy Schleich, has been sending them to foreign ministers of over 100 members. But another of those stakeholders we also want to influence is the ICC prosecutor himself. And on the subject of Ralph's opinion, I should say it's endorsed by a long and very impressive list of legal scholars, including Justice Richard Goldstone, who is on our panel, who we'll hear from in a moment. And Richard, as I hear the Minister talk about an ad hoc tribunal, that immediately is something which I think we'd like to put to you later on. But can I go to Ralph now? Ralph, I want to begin where all this starts, and that's with the NUG Declaration, which, as the Minister has been discussing, was made public a year ago. I'd like your take as a legal scholar on that declaration and its significance, please.
Well, thank you very much, and it's a great pleasure to be here with everyone. So the legal significance of the declaration under the Rome Statute for the International Criminal Court is as meeting one of the preconditions for the exercise of jurisdiction by the ICC over a situation taking place in and involving accused persons who are nationals of Myanmar. So in any given situation that might potentially come before the ICC, other than if a situation is referred to the ICC by the United Nations Security Council, the ICC may exercise jurisdiction only if it's referred to the prosecutor by a state party to the ICC statute, or the prosecutor initiates an investigation of his own motion. So let's keep these two things in mind: a referral or by a state party, or an investigation by the prosecutor of his own motion. In either of those two cases, before jurisdiction may be exercised, there are preconditions that have to be met. And for present purposes, the key one is the state in whose territory the conduct in question occurred, obviously in this case Myanmar, or the state of which the person potentially accused is a national, again in this case Myanmar, are either a party to the Rome Statute or as a non-party gave their acceptance to the exercise of jurisdiction by the court through a declaration. Because Myanmar is not a party to the ICC statute, and we don't have a Security Council referral, the effect of these provisions is that for ICC jurisdiction to be exercised over a situation taking place in Myanmar involving an accused who is a national of Myanmar, Myanmar needs to have given its acceptance as a non-party to the court's exercise of jurisdiction. So the potential significance of the declaration then is as serving as such acceptance, thereby meeting the precondition, this precondition for the exercise of jurisdiction over such cases. This doesn't mean that jurisdiction will necessarily be exercised. That would depend on further steps. So the legal issue clarified in the opinion being launched today is whether the declaration falls under the scope of what is envisaged as a non-ICC statute state party acceptance of jurisdiction under the statute. And so more broadly, of course, whether or not the NUG could legally act as the state for the purposes of that acceptance under the statute.
And Ralph, if I can just jump in, you, in this incredibly authoritative opinion, argue that the ICC has a clear legal obligation to accept the NUG declaration. Talk us in as non-legal a way as possible, please, through that argument.
Yeah, for sure. So it's important to start with a general point, of course, which is the position of the NUG as a matter of the political and constitutional arrangements in Myanmar. It is, of course, the legitimate government of Myanmar as a matter of domestic law, since it was formed from members who were elected under the constitution and is committed to democratic, pluralistic, and constitutional rule, the rule of law and the promotion of human rights, and is the only alternative to the junta, which is manifestly and inherently illegitimate, unconstitutional, and undemocratic, and engaged in widespread, systematic, and grave human rights violations. It's also notable that the question of de facto control exercised within Myanmar is in flux, with significant areas and population groupings not under the control of the junta, while the NUG is also aligned with certain armed actors that do control significant parts of the country. So yes, in the opinion, I argue that the court is legally entitled and indeed legally required to accept the declaration as a valid acceptance of the court's jurisdiction by the state. And I draw that conclusion based on applying the 5 relevant areas of applicable international law. So firstly, if I can run through them quickly, the first area is the general rules of international law relating to the recognition practice of states, which entitle the ICC to recognize the NUG as a valid authority to issue the declaration. In the second place, the international legal standards adopted by the United Nations General Assembly when accrediting state representatives at the United Nations. And accepting the NUG as being a valid authority to issue the declaration would be consistent with and follow from a diverse set of precedents drawn from similar situations. In the third place, applying these UN standards on accreditation as they have been applied to Myanmar since the coup, accepting the declaration as valid would follow from the decision made by the UN General Assembly in December 2021 to permit the NUG representative at the UN General Assembly in New York to continue acting as the permanent representative of Myanmar to the UN. In the fourth place, for the ICC to accept the NUG as capable of engaging the state of Myanmar so as to render the declaration legally effective would be to follow from and be consistent with, and in one respect potentially required by, 2 related international legal positions that have been adopted generally by states and the UN on Myanmar. So firstly, of course, there has been consistent and widespread determination by states and all the main relevant UN bodies and officials that the junta is illegitimate. Moreover, there's been an act of collective recognition of the NUG as the government of that state by almost all the world states when they voted unanimously in the UN General Assembly on accreditation before that body. And indeed, a case can be made that this collective recognition had legal standing in rendering obligatory the recognition of the NUG as the government of Myanmar. In consequence, the ICC would be required to accept the declaration as valid insofar as the question of the NUG's capacity to act on behalf of Myanmar to issue it is concerned. In the fifth and final place, as a matter of the internal law of the ICC statute, the object and purpose of the statute to end impunity requires the ICC to accept the declaration as valid for the purposes of meeting this precondition for the exercise of jurisdiction.
Got you, Ralph. Thank you very much for that. I'd like you to take off your legal scholar's hat in terms of all the stakeholders, including the NUG and the parties of the Rome Statute. What could this all trigger, given what you've said about these preconditions being met, recognition of the NUG, in practical terms, in terms of all the stakeholders, what could come next?
Right. So the NUG declaration means that this precondition for the ICC to exercise jurisdiction over the situation in Myanmar, even though Myanmar is not a party to their own statute, that precondition is now met. So if I can briefly make the comparison that's often in many people's minds is with Ukraine. This is the same situation as Ukraine, also a non-party to the Rome Statute that made two such declarations. So for the court to go on to exercise jurisdiction, as is now happening with respect to Ukraine, either the situation needs to be referred to it by one or more of the states parties to the Rome Statute, or the prosecutor needs to initiate an investigation. And again, bringing in the Ukraine comparison, the day after the prosecutor announced his decision to seek authorization to initiate an investigation, referrals by states parties, which currently stand at over 40, started to be made. And that is now the basis for jurisdiction going forward in relation to Ukraine. So in this case, in the case of Myanmar, it's now for those states parties to the statute and the prosecutor to demonstrate that the lives of the people in Myanmar count as much as the lives of people in Ukraine. States should make referrals, and the prosecutor should seek authorization to initiate an investigation. Given that the NUG declaration provides the gateway for action, the prosecutor and the states parties have no excuse for further delay.
Ralph, here. Thank you very much for your very clear legal analysis and your very clear, those two ideas of what can happen moving forward. Just Ralph, before we leave you for the moment, is there anything else you want to add to that very clear to-do list you gave us at the very end, or are you okay for the moment?
I would just say very briefly, all it would take at the bare minimum would be one state party to the Rome Statute to refer the situation to the court to trigger jurisdiction. States parties should be aware that the power to bring accountability through the International Criminal Court to this situation is in their hands. So I'd encourage everyone watching and listening to check whether their state of nationality is a party to the Rome Statute, and if so, to lobby their government to make a referral.
It's a chance for a state to go down in history as the state that brought accountability to Myanmar, potentially, Ralph. Is it that big a deal? Right. Can we say that?
Indeed, yeah. Indeed it is.
Okay, Ralph, thank you for the moment. We're very, as I say, we're very proud in MAP to have been able to work with you on this quite brilliant legal opinion, which, as I say, we've sent to the court, we've sent to over 110, I think it is, member states. I'd like now to turn to Antonia Mulvey, who founded and is the director of Legal Action Worldwide Law, which works with individuals and communities to achieve justice for human rights abuses. Antonia was also part of the UN Independent International Fact-Finding Mission on Myanmar, which the Minister referred to as having collected all of this, millions of pieces of evidence. At the IIMM, Antonia held the file on sexual and gender-based violence and children. Antonia, thank you for sparing us your time. We're very grateful. You've been involved in a number of initiatives supporting ICC investigations. Tell us a bit more about the nitty-gritty of the mechanism for making the referral, which is one of the big ticket items on Ralph's to-do list.
Oh, thank you so much. It's always a pleasure to be part of these panels. So thank you so much in particular to you, Chris, to Matt, and of course, my fellow distinguished panelists. Now, just bear with me a moment, because I'm going to repeat a few things that Ralph said, but only because I think they're really vital and important. So before a court can make a referral, let's just quickly remind ourselves how the ICC can exercise jurisdiction. I will be brief. Number one, we heard from Ralph, a referral by the UN Security Council. It first happened in Darfur, but last one was 2011 in Libya. So that's a stalemate. Secondly, we heard again from Ralph that the prosecutor can open a preliminary investigation into any crime within its jurisdiction. But again, note, only if the state has ratified their own statute or accepted the jurisdiction of the court. And the pretrial chamber must authorize a full investigation. Where did that happen?
Just explain pretrial chamber for those who may not be acquainted with it.
The pretrial chamber is a part of the court, and they are sitting as judges and have to accept and authorize a full investigation. Now, I'm going to give you an example that many people watching will be really familiar, and I think a brilliant initiative from the prosecutor's office. Of course, it's a situation of Bangladesh and Myanmar, when Bangladesh has ratified the Rome Statute, but Myanmar had not, and when hundreds of thousands of Rohingya crossed from Myanmar into Bangladesh, it was argued that the continuing crime of forcible deportation had taken place. And that had allowed the prosecutor to make that request, and the pre-trial chamber, at the request of the prosecutor, then authorized a full investigation. And we're going to talk about later, I hope, the role of survivors. And it's been really inspirational. It's been inspirational also to many survivors across other countries. Syria have now made some Syrian survivors made a similar submission. We've also seen it in South Sudan and also with the Uyghurs. So, Chris, let me get on to your real question about a referral by the state party. That's a state party to the Rome Statute under Article 14. Again, note, though, the prosecutor has to decide whether to open a full investigation, but it does remove the need of the authorization of the pre-trial chamber. So you add one, but you remove one. Where do we have examples of this? Mali, DRC, and CAR. And of course, as we've heard from the minister, it's absolutely, and Ralph, crucial for the NUG declaration. And again, this is a situation that we keep thinking about in the situation of Ukraine, where 43 member states made the referral. I think it's 43. Ralph said over 40. We're looking at that. But again, I was thinking about this. Of course, as we heard, they made a declaration in 2014. So let's think about that. It was sitting pending for 8 years. So what did that member state referral do? I would argue it speeded up that process and assisted the prosecutor to open up a full investigation. So I think I can talk a little bit more about that Assembly of State Parties if you wish.
Please, yeah, please. I mean, how do you influence them? That's the key question, because clearly it's members, as Ralph said, one single state can refer. You've worked with the Assembly of States Parties at their meetings. How do we go about motivating them?
So I guess the first question we have to ask ourselves is, who is the Assembly of States?
Yes, of course.
So that's 123 member states who have ratified the Rome Statute. Now, if we think about how we're going to, it's a tricky question, isn't it? How are we going to influence those member states? And I was thinking about this, what will change their behavior, but we're actually not changing the behavior of states. In fact, we need to influence and change the behavior of governments, that government that is currently in power. And I think, put simply, bluntly, we have to be, I'm going to say it, 2 words: politics and money. And I think we need to look at those member states who perhaps already made statements in support of accountability, of the violations and abuses that have taken place within Myanmar, and also those who have very limited financial links with Myanmar, trading, business, is absolutely crucial. And time again, we've heard that states won't come forward because they have those business links, those financial links. And again, who is supporting funding within Myanmar? So we could start, of course, by looking at some of those member states who've already made some of these statements or joined other justice initiatives. Of course, we've seen Canada and Netherlands making declarations for their intentions to join the International Court of Justice, case of Gambia versus Myanmar. We've also seen, of course, Gambia, who initiated that, and also Maldives have made a declaration of their intention to join. And Maldives might be quite interesting because also it's nearer to the region, and I think that's quite influential and important. And of course, although we only need one, I think we've seen the really importance of gathering a number, and particularly from the region which it's taking place.
There's an interesting question. How do you motivate ASEAN, and many, of course, of whom are not signatories to the Rome Statute? But let's talk a bit. I asked you before, Antonio, you've done amazing work at law in influencing the Assembly of States parties. How would you go about doing that? What sort of arguments would you use in the case of Myanmar and the NUG Declaration and the whole question of referral?
Well, I'm going to answer your question in a slightly different way. I'm going to say that, how are we trying to influence? Well, we're putting survivors and the victims right at the very forefront, Chris. We actually represent hundreds of Rohingya survivors from the 2017-2016 clearance operations. Many of them are women, and many of them, both men and women, who suffered from brutal, horrific sexual violence. And we believe by empowering them and having their voices heard by member states, that's been absolutely crucial and critical in driving these justice processes, not only the ICC, but also the International Court of Justice. And if I may, I'd like to just give you a couple of examples, and I think how it can be influential within these processes. Now, I want to talk about a group of women called the Shanti Mahila, incredibly brave women, many of them who had their husbands killed in front of them, who suffered from sexual violence. Now, in 2018, they made a victim submission to the prosecutor, arguing in 2018 they can't read or write, so it's actually their thumbprints on the submission, arguing that the court could have jurisdiction over the continuing crime. So that's the original submission made by the prosecutor, arguing jurisdiction because Bangladesh has ratified the Rome Statute. Now, when the court authorized the investigation, it was noted, the registry noted the victims unanimously wanted this. So it's absolutely vital that we put them at the forefront. Do they want this? Because not everybody wants an ICC investigation. We know that from the many countries that we work in. Also in 2020, we are supporting them. We made a request to the court on their behalf for the hearings to take place in Bangladesh, if the ICC trials do actually go to that stage. Now, that request was refused, but the court noted that the victims were right to ask, and they will reconsider that if it moves to trial. So again, we see they have a vital role to play. And then again, in 2021, we made an Article 15 submission arguing that the prosecutor could accept the NUG declaration on behalf of Rohingya victims and survivors. I'd just like to make a final comment about this. I think,
please.
I know this panel is focused on the International Criminal Court, but victims and survivors, there are many different ways to find accountability. And I'd like to congratulate you, Chris and Matt, for taking these other initiatives. As we also heard from the Minister, criminal accountability can be through using extraterritorial and universal jurisdiction. We also have state responsibility through the International Court of Justice. From our work with thousands of victims, they want accountability in many, many different ways. And financial accountability is not only criminal accountability, which is really, really vital for us to think about.
Antonia, that was absolutely brilliant. Thank you so much for your contribution, and thank you for your work with law. And actually what you say about working with victims and how they can work to support cases at the ICC and in other international criminal mechanisms segues perfectly into our next panelist, which is Wei Wei Nu, who is the founder and executive director of the Women's Peace Network in Burma and visiting senior research fellow at the Human Rights Center at UC Berkeley. She spent 7 years as a political prisoner in Burma. Since her release from prison in 2012, Wei Wei has dedicated herself to working for democracy and human rights, particularly on behalf of marginalized women and members of her own ethnic group, the Rohingya. Wei Wei, it's a real honor and a pleasure to have you on our panel. Thank you so much for getting up early in the East Coast of America to be with us. I want to ask you with a very general question. What interactions has your network, have you and your network had with the ICC?
Thank you very much, Chris, for your question. I'd like to begin by emphasizing how important it is for the ICC to find innovative ways to engage with the civil society and victims and survivors for the crimes related to Myanmar. And how important it is to ensure that the safety and security of civil society organizations aren't compromised when engaging with international mechanisms, such as ICC. I and Women's Peace Network actually truly value the ICC's roles in bringing justice to many of the victims and survivors of the military crimes. We find that any act aimed at genuinely bringing justice to Rohingya is incredibly valuable, as long as it process is rooted in direct and active engagement with the community. From what I have heard, steps towards these actions are being taken. Most recently, earlier this year, the ICC prosecutor conducted his first visit to the Kutupalong refugee camps in Cox's Bazar, Bangladesh, to meet members of the community, as well as its women, youth activists, and imam, and other religious leaders. The prosecutors also met officials from the Bangladesh government in Dhaka. So what we hope is that the ICC investigations addresses the needs and concerns of the entire Rohingya community, as well as other people in Myanmar. For this to happen, the investigation must cover the entirety of the crimes committed against all people in Myanmar, so that justice is served to all of them. Our understanding is that the court has now only authorized an investigations on the crimes that were committed against Rohingya, at least in part on the territory of the Bangladesh, which is a state party to the Rome Statute. So for now, the crimes can be guaranteed to include crimes that were committed against Rohingya, basically, which is very limited, could perhaps be the crimes of deportations and persecutions. Therefore, I think it is vital to ensure that the court has full jurisdictions over all crimes committed in Myanmar, and in a way which will allow for their perpetrators to be prosecuted. And the process should involve the acceptance of the Article 12.3 of the Rome Statute, or through the UN Security Council referral of the country's situation to the ICC.
Thank you, Wei Wei. Can I ask you, are there positive spin-offs in the work that you've been doing if the court were to start investigating Myanmar since the coup last year?
I mean, obviously, yes. The ICC's effort to investigate the crimes committed against all the people in Myanmar since last year, or the crimes committed before last year, before the coup, would have been momentous, just as any similar effort from the international community would be. Unless further actions from the international community is taken, more and more of the country's people will be rendered victims and survivors of the military's crime. So it is important to know, actually, so I must say that yes. And on now with the current processes, I think it is very important that as I mentioned earlier, ICC engage with the community members and the civil society meaningfully, and also try to understand what the victims wants.
Well, I mean, that begs the question, what do the victims want? And I quite agree. I mean, these international justice mechanisms do seem must seem very, very remote. What do you want from them? What does your network want from them?
I think it might. I think that we cannot actually say what we want, because we cannot represent the entire community, entire victim communities, even within the Rohingya. So that is why I think it is critical for the court to really have meaningful engagement with the different victim groups and try to understand what people want, because it may be different. Some people may want, it may be different from each victims groups or among different victims and survivors. So some people may want, to see the criminals punished, or some people may want to may prefer monetary compensations, or a lot of people may want to see justice is restored in a way that their dignity and their rights in Burma is restored, or a lot of people may prefer to return to the places of origin. So I think that definitions of justice for the Rohingya community, it's beyond what we are actually thinking and discussing here. So I think it is for now, for not only for the ICC but all other international justice mechanisms, it is crucial to understand what's the community really want. My hope is our hope is that it is crucial. We need criminal accountability, and this form of retributive justice should pave the way for the effective and meaningful rehabilitation, redress, recovery of these victims and survivors of genocide. And actually, many victims whom ICC may survey don't necessarily want to end up before the court. They want to actually, they just want people to know what happened to them or their communities, right? And want international community to respond to the needs and concerns for their justice. Or, in most cases, people simply want to improve their situations right now, the situations in the camps or in Bangladesh. So I think all of the effort through the ICC or other investigative mechanisms, all of this, I think, should be able to answer just the justice for the community as a whole, as it is as meaningful as possible for to improve in or to safeguard in the situations of the people at the moment, as well as paving the way for the future, not only the criminal accountability, but also other restorative justice and redress and recovery of the community.
Wei, we'll come back to you, I'm sure, in the question and answer session. But for the moment, thank you very, very much indeed. And finally, to Justice Richard Goldstone, who's been waiting very patiently, founding Chief Prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda, and retired Justice of the Constitutional Court of South Africa. Richard, welcome and thank you. Given your long experience of navigating the politics of international justice mechanisms, including the ICC, what do we need to get the ICC, what do we need to do to get the ICC to engage seriously with Myanmar? Some broad thoughts, please.
Well, I think, Chris, firstly, thank you for inviting me to join this panel. It's a great pleasure. Your question raises a very important issue, and that is the politics of international criminal justice. Without the politics, the system doesn't work. On the other side, obviously, one has justice and ethics. There's a situation that has been referred to very importantly by Wei Wei Nu, and that is the recognition that many hundreds of thousands, if not over 1 million, victims in Myanmar are calling for. That recognition is fundamental to international criminal justice. It's the victims who are really the customers of the whole system. So one's got to get that as the background. Obviously, the importance of victims and recognition for victimization for those who have suffered from victimization. But to get the ICC going, there is the politics. One has seen with Ukraine, I think some 42 member states of the Assembly of States parties requesting the prosecutor get involved, made it very difficult for the prosecutor not to act quickly, and he did. It's very difficult from the outside and not being intimately involved with the office of the prosecutor to know what the pressures are, both from a logistic point of view, from a resources point of view, from a political point of view, to be able to make judgments. However, having said that, by way of background, if I may, I think it's very important that Myanmar is an exceptional case in the ICC, because there's already, as has been referred to, particularly by Ralph, there's already an investigation into the crimes committed in Bangladesh, which is a member of the Rome Statute. So the court, the prosecutor, is already involved in a Myanmar situation, and it's important that the current prosecutor, Karim Khan, visited Bangladesh for 5 days in February of this year, and he met with many of the victims who have been forced into Bangladesh, and he stated to them in their presence that the crimes against the Rohingya would be prioritized during his term of office. So there's already that commitment, and it seems to me that there's an obviously a way to pirouette, as it were, into Myanmar itself, because of the declaration made by the NUG, which has been referred to by the minister and by Ralph. So I think the politics demands that civil society must act where it can in member states and put pressure on governments to add to the call for justice in Myanmar.
Richard, if I can ask you, I mean, you've mentioned the prosecutor, you mentioned his trip to Cox's Bazar in Bangladesh, but as Ralph has explained, there's another route, which is a referral by a member state. Given your long experience of dealing with them, what's the best way of making that happen?
Well, again, it's public pressure. I don't think one can overestimate the importance that civil society organizations have played and are still playing in international criminal justice. The Coalition for the International Criminal Court, the CICC, has power within the Assembly of States parties. It has an important voice, and I think it should be approached to become more active in pushing states parties to respond to the declaration made by the NUG. So it's civil society pressure, and it's for that reason that I admire very much the work that you and MAP are doing to bring this to public attention. That's the way to go.
Richard, thank you. You have had many dealings with the prosecutor, and you heard Minister Myo say they haven't even had a formal reply to their declaration. You've talked about public pressure in dealing with the member states. How do we deal with this issue of the prosecutor or the ICC apparently not having even formally responded to the NUG declaration?
Well, indeed, it's surprising. I would have thought that good manners at least would compel at least even a formal response to a declaration that has been made by the NUG, and especially in the aftermath of the General Assembly implicitly accepting that the NUG is the representative government of Myanmar. So again, I think it's public pressure. I think it's the media and so on that must highlight this and really put pressure on the prosecutor and on the ICC and on the ASP to respond to the declaration and to do something positive with regard to the terrible atrocities that are being committed in Myanmar.
And Richard, do you have views about the kinds of arguments that would motivate them? I mean, Ralph said rather eloquently, I thought, you know, does the court care as much about life in Myanmar as it cares about life in Ukraine? In your experience, what sorts of public advocacy messaging and levers should we be pulling?
Well, I think the public advocacy obviously must concentrate on the a terrible number of people who've been victimized in Myanmar. On very conservative figures, as I understand it, some over 2,000 people killed, over 1,500 detained, and over 1 million people displaced, and many millions of people requiring humanitarian aid. It is a case that cries out for investigation and by the International Criminal Court. The fact-finding mission has been mentioned a couple of times, and that has brought world attention to the enormity of the gender-related crimes which have been committed, the gender atrocities that have been committed in Myanmar. All I can say is if these facts don't drive at least some governments to exercise, to impose pressure on the ICC, I don't know what will. But I think one has to keep driving at it.
Yeah, we certainly will do that. Just before we leave you, Richard, on a practical question, I mean, MAP, in its dealings with various stakeholders, has rubbed up against this argument that the court doesn't have the time, it doesn't have the money, it doesn't have the resources, the judges are all terribly busy, in your experience, how do we deal with that?
Well, it seems to me it's important, I think, to push for transparency. I don't believe that any problems that there might be in the OTP justify silence. I think people understanding of the problems that the ICC has. It has very limited financial support. It has limited resources, a limited number of investigators. One understands that. But it's all the more reason, I believe, for the court to be open and transparent and to explain those difficulties and to explain what it's doing or what it's not doing. People are understanding, and I certainly, it was my experience in the case of the Yugoslavia and Rwanda tribunals. The media in particular, I found very interesting, very supportive, and very understanding of not being able to be too forthcoming, which obviously a prosecutor cannot do. But there is a call, I think, for more openness in this regard.
And Richard, before we leave you, very finally, you've already given us some very helpful ideas for our to-do list. Is there anything else in addition to what you said that you feel we should add to it that might be effective in engendering robust action on Myanmar from the court?
Chris, I don't think so. I think Ralph's excellent opinion. I think it's very important that you're getting it out there. Yeah. And I think it's important to get academics involved around the world in supporting that opinion and calling for more action.
And indeed, some of the delegations in The Hague, who I believe are actually on this webinar. Thank you, panelists. It's been wonderful to hear you speak from your own very important and interesting perspectives. We have a lot of questions that are coming in. Dear Excellency Aung Myo Min, my name is Win. I would like to know how we can concretely support the NUG in the legal proceedings. Is the NUG directly participating in the program? How can we help? Which funds, which evidence collecting? So Minister Myo, please, that's a broad question, some of which you've of course already answered, but please, would you respond to Win, please? Hello, Minister. I think we may have lost Minister Myo. I'd like to come back, if I may, while we gather ourselves here, to Richard and the question which Minister Myo raised about an ad hoc tribunal that was on his list. How do we get to that point where there is an ad hoc tribunal on Myanmar? Richard, please.
Well, the short route to get an ad hoc tribunal would be to get the General Assembly to agree to a request. The NUG would have to make a request to the General Assembly of the United Nations saying, please join us in setting up an ad hoc tribunal. This is what happened successfully in the case of the Sierra Leone Special Court. It was also the route that led to the Cambodia Tribunal being set up. So there is that mechanism. The Security Council obviously is not going to get involved. The veto by China and Russia, in this case, obviously precludes any Security Council action. But in the General Assembly, it may well be different, and you would need a majority vote in the General Assembly to agree to a request from the NUG to set up a special tribunal for Myanmar.
Right. Okay. Minister, thank you, Richard. Minister, are you back with us now? Are you able to answer that question from Win, who says he'd like to know how people can support the NUG's work at the ICC, given what you said about the declaration? You'd need to unmute yourself, Minister. I think Minister Mio is having some technical issues, in which case I'm going to move to a question from the independent human rights lawyer, Leila Hilal, who I believe is in the United States. Could pending national cases, for example, in Turkey, impact the ICC decision-making on whether to exercise jurisdiction? Ralph, I think that's possibly one for you and possibly one also for Richard. So could the sort of case that MAP has in Turkey impact, or how could it impact the ICC process? Ralph, you're also on mute, by the way.
Chris, could you perhaps remind us all what those cases are?
So MAP has a case against 23 named individuals in Turkey. The individuals are in Myanmar, but the case is in Turkey, for crimes against humanity. The case has been accepted by the chief prosecutor in Istanbul, and it is a he, has referred it to the Justice Ministry in Ankara, and the Justice Ministry in Ankara is now investigating the junta, and it's looking into the accusations we have made, which is based around torture survivors, torture victims and survivors. We've done the legal analysis. We've shown that the use of torture is widespread and systematic inside Myanmar. And that's where the case now sits. It's being investigated by the Justice Ministry in Ankara. So Leila Hilal's question is, how or could that impact decision-making at the ICC? The fact that there are these national cases going on.
So the issue of complementarity is a separate question from where we are at now, and that could be considered as a later stage, but at that would not preclude, and that might have implications for things proceeding. But at this stage, it should not be a consideration to delay either the consideration of an investigation initiated by the prosecutor or a state referral. And of course, those domestic universal jurisdiction cases are complicated by a variety of factors, not least the issue of immunities, which don't apply before the International Criminal Court.
Yeah, and the other thing I presume that comes into play here is the fact that in Myanmar itself, it's absolutely impossible to get a fair trial because the court system there is a punitive, politicized tool in the hands of a very vindictive junta. Ralph, you're shaking your head. Do you want to say anything?
Well, yes, I mean, manifestly, there is no possibility of proceedings at the moment within Myanmar.
Yes.
So on that, when that comparator is borne in mind when it comes to complementarity, the test is met.
Yes, indeed. We have a question from Deda Rose. I'm in the US and I'm an ordinary citizen. What can I do to help the case? This is very similar to Peter Svensson's question. How do we ordinary people push states such as the EU to support? I'm going to bring in, if I may, Weiwei and Antonia, who have done some great public advocacy on this question. Antonia and Weiwei, let's go with Weiwei first. What's your answer to Deda Rose's question and Peter Svensson's question? How can we, ordinary people, push states, she says, such as the EU, so regional groupings as well, Peter says the EU as well, how can we push those to support the work at the ICC?
I think what we are missing now is, because Myanmar is not a party to the Rome Statute, the ICC does not have jurisdictions over Myanmar to investigate and prosecute the entirety of the crimes. So therefore, as we have discussed earlier by the previous speakers and myself, there are two possible ways that could be the ICC can prosecute the crimes happening in Myanmar at the moment, in the past, and perhaps in the future. And that is for the ICC to accept the NUG declarations of Article 12.3 or through UN Security Council referral. So I mean, the NUG's acceptance of the declarations by the ICC, it's a very unique, and it's a very important questions that has been there, and I hope that the court will be able to come up with concrete answers and decisions on that. On the other hand, we still have a tool through the UN Security Council. And in the UN Security Council, what we're seeing now is that the UN Security Council itself, practicing double standard, and not necessarily taking into account of the suffering of the people all over the world, all different countries equally. The international community, the countries, the states that has a fundamental responsibility to protect human life, right to life and right to liberty. And now, in many parts of the country, including in Myanmar, human lives are in grave danger. And we have faced genocide, crimes against humanity, and war crimes, and continue to face them. And the council, who is mandated to protect these people and to use these legal tools to protect the people, are not using it. For the case of Myanmar, they've been ignoring forever. So citizens can actually push their states, their country, to really use their power and their authorities and their mandate at the UN Security Council, refer the situations of Myanmar to the ICC, so that ICC can actually have more options to exercise their jurisdictions and punish the criminals and end these atrocity crimes.
Thank you, Wei. You touched on this question of citizens' involvement at the end of your very interesting answer. I'm going to go to Antonia, but while I'm going to Antonia, can I ask you to think of a specific example of where citizen action actually had an impact, either at a local level to motivate a politician, a local politician or a national politician or whoever. And while you think about that, Weiwei, I'm going to go to Antonia to answer these questions from Peter and from Deda. What do you say to the question from ordinary citizens listening to this? How can they, sitting at home, in their communities, doing what they do, how can they assist and push these high-level international justice mechanisms?
This is a question that we're asked all the time. This is horrific. I'm outraged, but what can I do about it? There's a few really simple things that you could do. Vote. Get the government in power that you think will make the changes that you want. Secondly, identify the parliamentarians or the specific committees within your country that have made statements in support of accountability for Myanmar. Now, somebody mentioned, for example, the EU. Well, we look at the EU Parliament. They have specific committees that look at these issues, the Human Rights Committee, the Foreign Affairs Committee. They have heads of those committees. Letters can be sent, and you can request to make oral, even to give oral submissions or meet with them. You can send letters. It's really powerful, not emails, letters. Ambassadors, when they receive letters, and also MPs, are more obliged actually to respond to letters. So we encourage all those we represent, write a letter, and you can, write a letter saying this is what we want, very specifically requesting the recognition of the NUG Declaration to support civil society groups that are also requesting accountability. Create a campaign. Are there those that you know that feel like you? Social media, it's incredible. You can, on Twitter, you can create a momentum for that. We've seen that as well. It's not only traditional media anymore. Media is an absolute key role in this. And then finally, for example, in the US, you have specific ambassadors that are there looking at atrocity crimes who have been really outspoken. Ambassador Beth Van Schack, write to her and say, this is what we want. The US is extremely influential on these issues. So I think there's so much that you can do. And of course, reach out to us if you want any assistance on help with writing letters. We do that a lot as well. Thank you.
Thank you. Wait, before I go to Richard, there are a couple of questions, I think, for him. Is there anything else you'd like to add?
I think citizens' advocacies and campaigns are extremely important to shape the policies and to make the policy maker work, act. One good example is the genocide recognition campaign in the US, the atrocity determination campaign. Then it took a while for the US to actually say it what it is and make the atrocity determination, but it did. But now that the US, as a one of the key as a powerful country in the world and make atrocity determination, and recognize that the crimes occurred against the Rohingya genocide, crimes against humanity. Therefore, there is more room for us to really push the US to act at the Security Council and in general to really be active on the accountability path. I completely agree with Antonio on using social media to promote what happened in Myanmar and to promote the suffering of the people and to really call out the policymakers and their the leaders to act, as well as writing letters to them and making noise and mobilizing among the people in your constituencies are critical. And we still, we have had so many, we can see, you can find a lot of campaign around let's say Ukraine, and they need it a lot, and we support them wholeheartedly as well. But yet, we as a country coming from Myanmar, I don't think a lot of people in the US or in the Western countries even heard of the name Myanmar. So I think it is important that there are more committed individuals to promote what is happening in Myanmar around the world and push the policymakers using whatever available tool they have. And digital media is one of the key tools that we have to act.
Great, Wei, thank you very much, and thanks for the work that you're doing on all those things you described. A couple of questions, I think partly for Richard, but also Ralph and Antonia might want to opine, and others. What is the timeline for the ICC case, and who is involved in the case to know whom to support? But the main question is, what is the timeline? I fear the answer might be how long is a piece of string. But Richard, would you mind addressing, what is the timeline for a case at the ICC? A rather impossible question, but what's the answer? And the other related question, sort of, is who can be, Peter Svensson says, sued? How far in the ranks structure of the SAC, the junta, the failed junta, can the ICC go? So Richard, you first, please.
Well, certainly it is asking the length of a piece of string. They're really, there's no definitive timeline. We've seen preliminary examinations, some of them lasting anything up to 14 years in the case of Colombia, some a very short period of a few months. So it's very difficult to put any, it's really guessing in the dark to talk about any timeline. And sorry, Chris, I didn't hear the second.
Well, it was a question about immunity, and I could perhaps preface this by saying that in our case, in Matt's case in Turkey, we deliberately named 23 individuals, some of whom were very senior, because they might be covered by state immunity, something which Ralph referred to in his contribution earlier. But we went right down the command chain to some people who have actually been doing the torturing, and thanks to the fact that there have been defectors from the Tatmadaw, the Myanmar army, we've been able to get a very good insight into people further down the command chain. So the question is really, how far can justice go? I mean, we saw, Milosevic, Karadzic, Mladic in the case of Bosnia, but Peter Svensson is asking how far down the chain, how far up the chain, in terms of prosecutions, can the ICC go?
Well, clearly, the prosecutor's first aim would be to go as high as possible. And here one must draw a distinction between immunities in the ICC and immunities in a national court operating under universal jurisdiction, as would be the position in the Turkish case. In a domestic court, certainly the head of state and ministers, relevant ministers, would have immunity during their office. In the case of the ICC, that isn't the position. The ICC statute especially doesn't recognize immunity, and that's why heads of state, current heads of state, and obviously former heads of state are susceptible to the jurisdiction of the International Criminal Court. But it can go down all the way. The mission of the ICC, as appears from its statute, from the preamble, and from its judgment, is to go as high as possible and to get the most guilty. And the most guilty are the people who organize, who give the instructions. But that doesn't mean that one can't go down the scale of criminality and bring before a domestic court or the International Criminal Court people in the middle range, the so-called middle fish.
Yeah, Richard, thank you. Just checking with our panelists, there's nothing else that any of them would like to add. If not, I would like to read out some suggestions from MAP's Director of Protection, Damien Lilly, who's been instrumental in making this webinar and all the work behind it happen. A few suggestions, says Damien Lilly, for civil society organizations interested in the issue. 1, write a letter to the ICC Chief Prosecutor to request him to respond to the NUG Declaration. 2, provide a victim submission to the ICC, as has been done by Law and MAP. Write a letter to governments that are state parties to refer the case of Myanmar. And 4thly, approach the coalition of NGOs working on the ICC to take up the issue. That's a coalition which Richard had mentioned as being a particularly effective operator in all of this. So here, I think because of time, we have to draw this webinar to a close. I am profoundly grateful to our panelists for being so engaging, so kind, so intellectually generous in their contribution to this panel. So Ralph, Antonia, Richard, Minister Min, Weiwei, thank you so much from all of us for MAP. Until we have another MAP webinar, I wish you all an extremely good day and the promise that one day there will be justice. It's just a question of all of us making sure we get there. Thank you all very much indeed.